All right, good morning. My name is Anna VanCleave. I am the director of the Criminal Defense Clinic here at UCONN Law School, also an associate professor, and also a member of the Sentencing Commission. And I just want to express my gratitude. I am so honored to be here. I'm honored to be a member of the Sentencing Commission. I'm honored to be here in conversation with so many people. It's amazing to see this audience, and I know every time we have one of these symposia, the discussion is rich, the engagement is deep, and we move the ball forward in important ways. So I am so grateful to be here. Also grateful to Judge Pavia and to Alex and to the students and the members of the Sentencing Commission staff and everybody who made this possible. So thank you all so much for all the work that went into this. I'm also honored to be here among these panelists and to be the first panel that starts this discussion about pretrial justice in Connecticut. I know the individuals who are on this panel and know the work that they do every single day in order to aspire towards a better system every single day than the one that we have, and to improve it every opportunity we get. So I will just briefly introduce each of the panelists, and then I'll let each panelist say, as is relevant, a little bit about themselves and their background and what they bring to the table, by way of introducing the discussion about everybody's contributions to this important discussion. And so first we have John Day is the acting chief public defender for Connecticut. Kevin Lawlor is the Deputy Chief State's Attorney. Ray Boyd is the Program Manager for Yale's Law and Racial Justice Center. And Mike Lawlor is an Associate Professor of Criminal Justice at the University of New Haven. And to get us all started with this discussion, I will throw out to our panelists and let each one talk in greater depth about the issues. But just to address the point that we're at right now in pretrial justice reform conversations in Connecticut. We've been engaged in these discussions for a while. And what we know is that critiques of the cash bail system come from all sides and come from anecdotes and experiences and the data that we're seeing. And so I will just start the discussion by asking each of the panelists to talk a little bit about, given the critiques of the current system, points of dissatisfaction with the way that it has worked in the past, where do you all see the concerns about moving forward, the barriers that might be in place, how we might overcome those barriers, and also what do we need to know about the current system and about what the future might look like in order to continue on a path of eliminating cash bail. So I'll start with that. Maybe we'll start at this end with Attorney Mike Lawlor.
Oh, well, thanks very much. And for what it's worth, if you find this discussion interesting, you'll see a second performance a week from today at my home when my brother Kevin and I will continue this debate on Thanksgiving.
And if I can just say, the people who are most happy that we're having this discussion today are all of our other relatives who will have to be spared the elaborate discussion that we're having today, and we'll get the Reader's Digest version on Thursday.
There you go. So in any event, first of all, thank you for inviting me. This is something I've been interested in for many, many years. And I think it's always important, before we have a discussion of what to do in the future, is to understand what exactly is the problem that we're trying to address. And I think the easiest way to set the stage for what the problem actually is to give you some statistics that might otherwise seem boring, but to start with this simple statement, and this is my opinion, right? Given the pretrial detention system we have, in other words, the system that determines who is incarcerated pretrial and who is not. As it turns out, there are many people who don't really need to be incarcerated who are locked up for weeks, sometimes months, simply because they're not able to post bail. On the flip side, there's a lot of people who truly are dangerous that are easily able to find someone to post bail on their behalf, even with multiple arrests and relatively high bonds. And so those are two sides of the same coin. Both, to me, are a serious problem. It's worth noting that in our state, there's a lot to be proud of in terms of our criminal justice system. For one thing, we have one of the lowest rates of reported violent or property crime in the country. I mean, we're consistently in the bottom 10 in terms of rates of reported crime, so I think we should be very proud of that. We have one of the lowest rates of overall incarceration in the nation, which is something I think is a testament to the great work that criminal justice professionals of all stripes do every single day. But there are some problems, one of which is the system by which people are confined in prison or jail before they're convicted. And I think that's best illustrated with some numbers. So for example, in 2016, so what's that, 8 years ago, 22% of everyone who was incarcerated in our state was being held pre-trial, 22%. Today, it's 36%. That's a pretty significant increase. Keep in mind the prison population has shrunk a lot. There's a lot fewer people incarcerated now. You know, we're almost at 11,000 total people incarcerated. In 2008, we were at 20,000. So it's a pretty significant change. But there's this huge percentage of people, many of whom will only be incarcerated pre-trial. In other words, the time will come when they'll go to court, their case will be disposed of, and it will no longer require them to be incarcerated. And we know the exact numbers of that. Right now, it's about 400 per month go from jail to the courthouse and don't return to the Department of Correction, meaning something happened in court that did not require further incarceration. And to me, what I interpret from that is that a combination of judges and prosecutors and defense attorneys came to the conclusion that the outcome of the case doesn't require incarceration, which to me begs the question, why were they locked up in the first place, right? Was there some public safety concern? Because if there was, one would think that that would warrant further incarceration down the road. These numbers are significant, and they're very different than they used to be. So I think it's fair to say that we have a unified court system. It has two levels, Part A, Part B. I think almost everyone here is familiar with how this works, but the most serious cases typically are dealt with in the Part A, the judicial district courthouses, right? It's actually less than 4% of all the cases that come in to the court system each year. The vast majority are handled in the GA court system, and there's virtually no trials in the GA courts. There's not zero, but it's pretty close to that. It wasn't always like that. There used to be more trials. And actually, this might be a surprising statistic for all of you, the number of new cases coming in the front door of our GA courts statewide today is less than half what it was 15 years ago. So 15 years ago, there was 116,000 new cases added to the GA court system throughout the entire state, throughout the entire year, 116,000. Last year, it was 58,000. So it just gives you a sense of how things have changed. But that being the case, the number of pending cases each year, meaning at the end of the year, how many cases are still pending, has actually gone up. So there's about half as many cases coming in, but the backlog is building. It's gone from about 21,000 cases still pending at the end of the year statewide in GA courts 15 years ago. Now it's 26,000. So this backlog is building up. And earlier this year, the American Bar Association issued a report of their plea bargaining task force. And I would encourage everyone who's interested in this topic to go back and read that. It's just called Plea Bargaining Task Force, American Bar Association. Recommendation number 8 deals with bail. And they recommend, and I think this stands to reason, that the use of bail, in other words, pretrial incarceration, should not be used to incentivize plea bargains, to get people to plead guilty. And that's a concern I have. As I said, we know every single month 400 cases go to court, 400 defendants go from jail to court and don't come back. So in those cases, I'm guessing almost all of them pleaded guilty, got time served, got probation, something else. Maybe a few got the charges dropped, who knows? Maybe their bail was reduced to a promise to appear, but they didn't come back to jail. And so that's the concern that's expressed as a national problem. But I think it's especially true here in Connecticut, and here's why I think that. And this, I think, is the topic of the discussion today. Should we make some significant changes in our system, this part of the system? I think we should. I think we should adopt a system that allows identifiable dangerous people, where the state can provide evidence that this person continues to be a threat to the community, allow them to be held without bail. But on the flip side, I think, absent that type of showing, people should not be incarcerated pre-trial. And let me give you one practical fact about this phenomenon and how it affects the overall system, not just the criminal justice system. People who are held pre-trial in the Department of Correction, especially on the relatively low bonds, relatively less serious cases, are almost always very high needs individuals. Serious mental illness, serious substance abuse, homelessness. And when these people come into the Department of Correction, the amount of money the Department of Correction has to expend providing their constitutionally entitled health care is extraordinary. It's extraordinary. And if you don't believe me, just go look, as a case in point, go to York Correctional, the women's prison, where more than half of the women locked up there today are being held pre-trial, and on charges that are very different than what the men are held on. And almost all of those women have some level of serious mental illness. And the amount of money that Connecticut taxpayers have to spend to provide that care, sometimes just for a few weeks or a few months because they're only going to be locked up pre-trial, is extraordinary. And an interesting fact that I think many people are not aware of, when people are incarcerated and get health care from the state, none of that is reimbursed by the federal government through Medicaid, none of it. They're ineligible, the state is ineligible for this reimbursement. However, if the same exact care was provided in the community, Connecticut taxpayers would get 80 or 90% of that expenditure reimbursed from the federal government. So that's just a long way of saying there might be a better way to deal with offenders who, I think if you work in the criminal system, you see these people all the time, low risk, high needs, repeat offender, in and out, in and out, in and out. If we had the mental health services and the substance abuse services and the housing options in the community, I'll bet you a lot of these people would not have to be put into the lap of our local law enforcement and have them figure out what to do when they really only have one option, and that is handcuffs and brought over for a bail hearing at the local court. So this system is not just about one rule or one set of players. This is a systemic problem that all of our state government and our local governments have to deal with. But I think I would prefer a system where we amend our state constitution, as is the case in almost every other state in the country, and allow for people to be held pre-trial without bond if it can be demonstrated that they're really dangerous. But other people are not. And I don't prefer the New York system where it's based on the charge. I do prefer the New Jersey system, which is based on a real assessment, regardless of charges, because as we all know, domestic violence charges are typically relatively minor, but the risk is relatively high in many, many cases. So that's my big picture point of view on this topic.
Thank you, Mike. Why don't we just go down the line? So I'll turn it over to Ray Boyd.
Yeah, thank you guys for having us all here today and inviting me to speak about this. Back in July, I was able to go down to New Jersey and spend the day with Judge Martin and witness some of the hearings that were taking place down there and the risk assessment that was taking place. And I was kind of being someone that just served 30 years in the Connecticut Department of Corrections, I was kind of taken aback that Connecticut, which is normally leading in all of these issues, it hasn't taken up a system like the New Jersey system with regards to bail. I can sit here all day and echo most of what Mike has said with regards to that. And I think the one thing that we need to always be mindful is that when someone is charged with a crime, there's always that they're innocent until proven guilty. So a lot of times I watch some of my friends spend decades in prison, and they were innocent. I think if they would have had an opportunity to be released on the bail, some of these guys were working the entire time when they were, before they were charged with the crimes that they committed, and some weren't, but the fact still remains that they were innocent of those crimes. However, they had bails that they couldn't post. And I think the bail system wasn't necessarily set up to keep people in prison. It was set up to assess the individual and to make sure that they had an opportunity to be able to afford bail. Connecticut has moved so far away from giving individuals that opportunity to where we're at today, where we need to get rid of a cash bail system in our state and be able to afford individuals to be able to, go to work and go to school. I'm going to steal a story that we just shared this morning. There was a young man in Enfield, Connecticut, that was he was charged with bringing a BB gun to school, but now he has $100,000 bail. He's probably already coming from an economically strapped environment. We don't really know the root cause as to why he chose to bring a BB gun to school, but now we have a young man who was obviously in school, making efforts to stay in school. I didn't make those efforts. I was a 7th grade dropout when I went to prison. I made some wrong decisions throughout my life, but I question whether we continue to introduce this young man and young men like him to a system that will only do him more harm than releasing him into the custody and giving him stipulations of a bail, if the judge was allowed to risk assess. I don't think a judge would say, you know what, we're going to give him a $100,000 bail where he won't be afforded to get out. His parents may never be able to raise that type of money to get him out, and he becomes indoctrinated into a criminal mindset while he's sitting there. Or he takes a plea bargain for a BB gun when he really wasn't going to harm anyone with a BB gun. And I know, and this is not to make light of our school systems and the things that have happened across the country with some of our students with violence, bringing, guns to school and so on and so forth. But I just think that the people that are affected by these astronomical bail systems are black and brown people, and there needs to be a serious change in our system that reflects a just system. And I think that it's about time that Connecticut decides to make certain changes and go in that area. So as I've been trying to help individuals transition back into the community, I'm also in the community trying to get them to understand and be supportive of such bills like this and become aware of such bills like this and begin to create community conversations where the community is aware of, what's going on at a legislative level and how they may be impacted if certain bills are not passed.
Thank you, Ray. I'll turn it to Kevin Lawlor.
Thank you very much for having me here. On behalf of Chief State's Attorney Patrick Griffin, who unfortunately could not be here today, I've had to sit in his place with the other guy at the other end of the table here. I just want to, express that from the Division of Criminal Justice perspective, we have certainly understand, as practitioners, as prosecutors in court, every day, the limitations of our current system. There is no doubt that a system created by humans, run by humans, interpreted by humans can be better. This system is far from perfect that we have. Given the charge of this commission, Chief State's Attorney Griffin has imparted on all of us the need to take this issue extremely seriously, both on the front end as we prosecute cases every day in court, and also as we look forward to the potential, should the legislature initiate or pass a bill regarding this in a constitutional amendment, that we do the research up front in order to be able to give a strong opinion on what we believe a new system should look like. In that regard, the Division of Criminal Justice has visited just about every state that has a no bail, no cash bail system. We've gone to Illinois, we've gone to New Jersey on several separate occasions. We've traveled to Washington, D.C. to kind of determine what all of these places do really well, what are some of the unintended consequences that they've seen, what are some of the issues that have arisen where they've kind of had to learn best practices moving forward. So we do look forward to providing that type of information as this process moves forward. I think in order to provide some context, however, for some of the stats that have been bandied about, I think it's just important to remember that the folks who are out there doing the job every day, that's judges in the GA, public defenders, the pretrial support, court support services, are out there every day understanding that this, particularly the low bail population, is something where people are trying every day to find whatever means necessary to keep people out of that incarcerated population. Now, my brother is correct, that the percentage increase has been dramatic in the pretrial detainee population compared to the sentenced prisoner population. But, one of the reasons for that is because over the last several years, the sentence population has gone down dramatically. It's gone down from a high of, about 15,000 down to now around 10,000. So the one thing that is, I think, astounding is that the pretrial detainee population has remained basically flat for the last 20 years. There's been incarcerated pretrial between 4,000 and 3,500 people over the course of that time. And I think a credit to the judges, the prosecutors, the public defenders, and certainly Court Support Services Division to find alternatives for people in this population is the fact that during COVID, for 2 years, we had no trials. We had no vehicle really to dispose of cases pre-trial. The population remained pretty much static, with cases coming in and very little going out. And during that entire time, the pretrial population stayed relatively the same. Murders didn't stop happening, robberies didn't stop happening, sexual assaults didn't stop happening. But the pretrial population did not go up. And I'd like to see another state where that occurred, because it didn't. And I think that's a credit to the fact that we use the bail system to the extent possible to detain as a priority the most dangerous individuals. I believe it's around 63 to 65% of the entire pretrial prison population right now is detained on about $150,000 or more. So if it's an imperfect proxy for risk, but I think judges wield that power to set bond to a vast extent wisely, with all the proper information. And when possible, we're getting those people, those low-level offenders, out as quickly as possible. The last stat that I'll tell you about on that is, I believe, according to the Division of Criminal Justice statistics, individuals detained on less than $20,000 of bond over the last 10 years, the average stay in the Department of Corrections is between 2 and 3 weeks. And a lot of that is because they're detained they're charged with a criminal offense, and that's basically the one continuance for them to be able to find an appropriate place for them to go. not for them to just be put back on the street so that they can reoffend again, but to be able to give them a viable place where, while their case is proceeding pre-trial, they have the ability to succeed. So I think that that's important to remember, and that we are dealing with limited resources on that side. Everyone in this room knows that the criminal justice system is not the answer for our healthcare crisis. But it is, when people enter our system, and from the Division of Criminal Justice perspective, as Chief Griffin says, our North Star really is public safety, that our job is to keep the public safe and to be able to assist these people who come through the system. And we rely on our partners to be able to do that in the court system and in the nonprofit community. And I think that the prosecutors who are out there doing it every day are trying to do their best to do that.
Just to say, I did offer to switch seats with Mike, and Kevin declined. It sounds like we're all unanimous that the system needs to be changed, and there's a lot of factors here. I disagree with Kevin saying, well, if we release them out on the street to offend again. Not everybody that gets released is going to go out and commit another crime. Some do, sure. You certainly see frequent flyers and whatnot at the GA level. Let's all admit that happens. But there's other things at stake here with holding someone, and I'll get into my concerns a little bit about a binary system, either or, in a second. But the people in my organization, they just like the prosecutors, it's like, well, this is today. This case just came in right now. Let's take a look at the police report. What can we do? But, my people will then be scrambling together to get like letters from a doctor and something from their employer and trying to set up something, to bring in front of the judge to say, can we say that there's going to be counseling, or if it's a family violence case, they're going to stay over at their aunt and uncle's house while this cools down. So there's a lot of things that can be brought, but it's harried. I mean, these things, if you've ever spent the morning in, one of the 4 large city GAs in Connecticut, it's something to see. And it's fast-paced, and it's sort of right now. Like, what can I do right now? Well, one of the things that we're kind of glossing over here is, well, the judge does have the power to issue a promise to appear and let the person go home. So that is sort of that's one side of a binary system. You're not held. We don't have to put a bond on you. And that is right smack in the discretion of the judge that you're arguing in front of. And then there's risk factors, and there's concerns, and there's all kinds of things. And look, I don't, believe it or not, if you go into the criminal justice system, you're not going to find the defense attorneys and the prosecutors are miles apart on things. There are certainly shared concerns, and I'm not advocating that somebody who just got shot or just got caught shooting someone should be given a release at the arraignment date. That's probably unrealistic. But if we're sort of focusing our energy here on GA level crimes, which are lower level offenses, mostly misdemeanors and some low level felonies, then there are options. And as I said, one option is the judge can give the person a promise to appear. The judge can put somebody on a conditional release. The judge can give them a bracelet. The judge can do all kinds of things to ensure their return to court. But if we just say, well, let's just go to a binary either-or system where the judge is provided with a risk assessment, and let's read the risk assessment. I really want to get into the details of what does that risk assessment say, and what does it not say that's implied, and what are some other things in that device, that tool, that, is this like, okay, well, you scored an 8, so, I'm not going to release you. And if you're being held even for, say, 3 weeks' time until there's a revisiting and, under this system, then you're released, well, you probably lost your job at Home Depot because you weren't able to make it for 3 weeks' time, so there's that. In the case of a single mom who can't get together some sort of coverage for their children, now DCF's involved because you're incarcerated. So there are lots of details in something like this that, by the way, I'm in support of it. I don't want you to think that I'm saying absolutely not, but there's parts of the system that exist right now that do allow for somebody to be released. And I feel terrible about this young man who got put on obviously a humongous bond for the possession of a BB gun. That's certainly a terrible example of how it can go wrong. But there are things about the system baked in the cake that can go right. And, perhaps a little more consideration to these things, like what's out there as a safety net that can provide to the court as an argument at the arraignment. Well, Judge, he's willing to do X, Y, and Z. Can we just put him on? I mean, they do this with, you can get a conditional driver's license if you get a DUI because you can get back and forth to work. Not in every case, certainly, but sometimes. So what's available now? What needs to be adjusted and reviewed? And how actually does the binary system work? We had a group from my agency go down to New Jersey and came back and said that by and large, that system of in or out tended to break toward the defendant, which is a good thing. And in other words, if all you have is you're locked up or you're not locked up, it seems like it may break in the favor of the defendant, which, again, I'm in support of. And you're not going to find every criminal defense lawyer saying every single person should be released from jail and never held. We can all face facts that there are dangerous people, and there's a public safety interest and family safety and all kinds of things that have to get factored in. And if you're sitting on the bench and you're making a decision, it's a hard decision. This sort of shop-worn term, the devil's in the details. Well, it is a little bit in the details, and I'd really like to remain cautious but optimistic in a system like this. I'd like to see how does Connecticut implement maybe some of the things, as Kevin said, that they looked at in Illinois, and they looked at in DC, and they looked at in Jersey. What can we do to kind of keep the train rolling toward making reform? Obviously, there needs to be some level of reform. And as I said, it's an easy decision. Well, I'm going to put you on an unmakeable bond, and we'll revisit this in 3 weeks because your lawyer's going to file a bond reduction, and you're going to come in. But in the meantime, there's trouble with DCF, and you lost your job, and now getting you released might even be harder. Well, Judge, he doesn't have a job, and he's going to get kicked out of his apartment, so does the default become, well, we'll just hold him here? And I agree that Connecticut, and we can't confuse health care and, community-based services with incarceration. They're not one and the same. And so I guess, I would say I'd like to see, moving from what does it look like on paper to what does it look like in GA14 on Wednesday morning when, you've got a handful of arraignments coming in and this stuff is moving at lightning speed. And how can we better help our clients, things I mentioned before, keep jobs and keep your family together, at the same time understanding that not everybody just gets, a nod from the judge and gets released, because there are other considerations, and I'm not trying to, minimize those other considerations. So anyway, that's my piece for now. And I'm still open to switching seats if Mike wants to move.
Now, he'll just smack me in the head when I talk too much, so we'll leave him down there.
Thank you, John. I know as moderator I have a lot of questions for this really thoughtful panel, but I also know that this room is completely packed with people who are committed and passionate about working in the criminal justice system every single day, and also working with the families and community members that are impacted by it. So I will just throw it out to you. If there's a lapse and there are no questions, I'm happy to chime in, but I imagine that this audience has lots of questions for our panelists.
So actually, this is for the brothers Lawlor. So it's Professor Lawlor and Attorney Lawlor. As someone who's served time in Connecticut's prison system, I've been home for 5 years. I'm also a second-year law student. One of the things I want to, thank you. Thank you. I would love to ask this question. So it's a two-pronged question. First, I would love to know, has there been a report that shows what the difference is with the two bail reform changes that you have made? Has there been a report that's already been done in terms of the drops?
Do you mean in Connecticut?
Yes.
Yeah, so I'll give you one example, and this was controversial, to allow persons charged with crimes to post in cash, 10% cash versus, the requirement to hire a bail bondsman to do it. So I actually just got those data now that you ask. On the 10% cash bonds, and one of the predictions was that this would affect failure to appear rates, that it would get worse, right? So the latest information we have from the judicial branch is bonds under $20,000, where 10% cash was posted, had a failure to appear rate of 8.29%. compared to 14% for surety bonds, in other words, where there's a bail bondsman involved. And one of the arguments was that if you take the bail bondsman out of the equation, there's less oversight to ensure the person comes to court, and the opposite has been the outcome. So that's one outcome that has been studied. I'm sure there's more, but that's one in particular.
Okay. So with that being said, I'd like to take this case that Ray just mentioned, about this 18-year-old he was a senior, junior in high school, and he's now in the criminal justice system. And this kind of drives me a little bit to you, Attorney Lawlor, in terms of when you say, we look at the underpinnings of, you all have said it, the mental health, the substance abuse, but yet we use the fear-mongering with public safety. And here becomes my concern. With the bail reform we talk about, they are, let's say, in jail, you say it so lightly, at a couple of weeks, a couple of months, and then they go home, right? The issue becomes the mental turmoil and the impact incarceration has on people that starts the minute you walk through the door, and it doesn't end when you leave. It takes its toll many years down the road. So now we're starting this 18-year-old down this road, right? And I think one of the things that people don't look at and don't really think about is the amount of time that these young people spend in prison. And a lot of the reason we have frequent flyers are because people have these issues starting from childhood that is early on. And we understand, the criminal justice system is not a babysitter, it's not all these things, but it doesn't address the very issues that start these people down the road in the first place. Second point to that is there's no one size fits all. And I think in trying to do things like that, that's where we make our mistake. So rather than, we have 12 prisons in the state of Connecticut. We had more at one time. So rather than putting money into more prisons, because we already know the Department of Corrections budget is crazy, and they request more money time and time again because of overtime and other issues. I think putting that money into the healthcare, specifically the mental health and substance abuse aspect and services, might go a long way. But especially looking at our young people and the history that it comes with, I think that's something we need to take a look at, because that's where we keep consistently going wrong. We're perpetuating this cycle as we started with these 18-year-olds and young people This is what creates, and I'm not making a snap at you here, but for us to be proud of our numbers, let's be honest. We have people coming in and out of the system. What does success looks like? There's a lot of us in this room who are justice impacted, or a few of us, and what is it? Because there's a few of us that are unicorns in this space. That's not success. Success is making sure that they come out in whole, as a whole human being. And somewhere along the way, I'm not exactly sure where in our criminal justice system, to get an inmate number doesn't mean that I sacrifice my humanity or my dignity to go into the criminal justice system.
Well, if I can glean a question out of that, I think that it's important to realize that I don't take this lightly. No prosecutor takes lightly the request for bond. I don't think any judge takes lightly ordering a bond in a particular case. And I certainly think over the course of my career, over 30 years, the approach to that decision has changed immeasurably. When I started in 1995, people weren't even, we weren't being trained, we weren't being exposed to those types of ramifications that you talk about when someone is incarcerated. Certainly since Chief State's Attorney Griffin has taken over, since I've been the deputy chief for the last 6 years, and preceding that, even under Chief State's Attorney Kane, we have trained on what is required when we're making these types of decisions and to consider those impacts that you mentioned. So I think things are being done differently than perhaps years ago. So I think that's important to remember. And as I keep coming back to, the statute is clear. There have been legislative reforms, both on the cash bail side, but in the most recent legislative session, targeting people charged with violent crimes to have their bails going basically the opposite direction in order, because the legislature felt that violent crime needed to be addressed in a slightly different way. And the measures that my brother talked about, the Division of Criminal Justice supported. We weren't against the changes for the 10% court set cash offenders. Those are things that we believe are reasonable to do in order to assure that people in that lower end of the spectrum have the opportunity to be able to get out if it's not a public safety issue. So, to your point, I just want to make clear that we do not take that lightly. I don't think judges take that lightly. And they make decisions, whether it's in this case this is the first I've ever heard of that case, or in any other case, we make decisions, as John correctly points out, on a daily basis based on the facts and the law that we have in front of us at the time, based on our best professional judgment. And it's not made in a vacuum. It's made with a person who's been appointed by by a vote of the legislature to be a judge of the Superior Court to make the final determination. And that is, I think the decision that's being made now, and I think what we're all here for today, is understanding that system could be better. What is it that we can do to make the system better, whether it's a no cash bail system, whether it's other things that we can do in the meantime to address some of the specific issues that you get into. I think as everybody here has said, we're all for that. And so, this is one of the things that I think is great about having this group here together, is to be able to discuss these issues and then be able to try and find consensus, so no matter what comes out of this, that we can make a positive impact on public safety and also on the low-level offenders and the folks that you're talking about, so that we can positively impact our communities to a greater degree.
Good morning. I'm Anderson Curtis from the ACLU. My question is for Mr. Ray Boyd. Ray, given your experience, would you please give us one takeaway that you would like to see come out of this conference? Because, we talk about a lot of things, but all of us here in this room contribute to the criminal legal system in one way or the other, whether for stakeholders, advocates. But from your perspective, with your vast experience, what was one takeaway would you like to see come out of this?
For me, personally, I like to go back into the community and continue to educate individuals about the no cash bail system. Do away with the fear that we're just going to be letting people out of prison and they're just going to be going back into the community, victimizing the community again. I think a lot of times that's not what you see, and what Mr. Day said, it's not like we're just letting people out and they're just going to commit crimes the moment they get out. That's not always the case. I think sometimes we have a big mental health issue in the Connecticut Department of Corrections, and I've watched that grow over the decades. So it's telling me that we're housing people that have issues that aren't necessarily criminal at the base, and if we can get those people help, why not shift them out of the criminal justice system into the mental health system where they can be properly, diagnosed, properly treated for what it is. Even individuals that have addiction, we're bringing people into addiction. Look at our criminal justice system now. Look at our Connecticut Department of Correction. Look at how many ODs we're having. Look at how many people are experimenting with drugs that they had no idea existed when they first were sentenced. Now these drugs are being introduced into our system, and we have an influx of ODs. We have an influx of, people trying to address their issues by sedating themselves with these illicit drugs. Let's educate them. Let's get them where they can get the proper help and make our community a safer place. So it all comes with education.
Just a quick question for Mike. You cited a number of statistics. Do we know the rate of incarceration, pretrial incarceration in states that have gone to the no monetary bail system compared to Connecticut, how they relate?
I'm sure we do. I don't have it at the top of my head. It's worth noting that Connecticut's kind of unique because we have no county government, no county jails. So here everything's in a unified system. In most states, these data are collected on a county level, and so it's really hard to do apples and apples comparisons. So that's number one. Number two, I think it's unfair to describe some of these systems as no cash bail, right? I mean, even in New Jersey, even here, there's lots of non-financial conditions of release that judges can and frequently do order, including everything from house arrest down to, maintain employment or maintain education. So, I mean, there's lots of options available, and there's lots of sanctions available for people who don't comply with those non-financial conditions of release. It's also the case, I think, in New Jersey is one example where money bail is, in fact, imposed in a number of situations. It's just not as widespread as it had been before. And I think those who have worked in the system know the utility of posting cash bail in lieu of coming to court, and they just forfeit the bond, and you're, like in a motor vehicle type situation. So I don't think anyone is proposing a complete elimination of money bail altogether. I think people are trying to get to the point, and there was a recent state Supreme Court decision just a little over a year ago. I forget the name of the case, but it was the Chinese-American guy in New Jersey who had like a $14 million bail set, where the state Supreme Court said that upon a motion from a defense attorney, where it was very clear that the amount of bail that had been set seemed excessive, and the reason for it was the potential dangerousness of the individual, that a hearing could be requested to require the state to demonstrate dangerousness or danger to the community, right? To my knowledge, very few of those hearings have been requested, let alone have taken place. But still, here you see what is a concern that I have, which is if dangerousness is a factor in picking the amount of dollars that needed to be posted to get out of jail, then there ought to be some evidentiary showing to back that up. Not proof beyond a reasonable doubt and not decided by a jury, but this is what happens in these other states. Once you argue dangerousness, especially in the federal system, if you make that argument, then you have to back it up with some preliminary evidence. Hearsay is acceptable in those hearings, et cetera. So I think it's a relatively low bar, and I say this because anecdotally I hear, whether it's law enforcement or others, saying, well, this person has been arrested multiple times with guns, and he's a gang member and all this other stuff. Okay, great, put that evidence on in court. Don't just say it to the journalists who are asking you, why you're frustrated this guy got out. And I want to reemphasize something I said earlier on. The other part of the problem is that there's lots of really dangerous people who are able to post their bail and get out, hundreds and millions of dollars in some cases. There was 2 young people that were charged with murder of another young person down near where I live in New Haven. For both of them, $1 million bond was set. One of them easily posted it because their dad had the resources to do it. So this is what creates a concern in my mind about this. And the final thing I want to say is don't overlook the fact that the vast majority of people who are charged with a crime in Connecticut, for whom money bail is set, post it, right? A small percentage are not able to post it, and they're the ones sitting in jail. And in that group, there's a lot who I don't think are dangerous and are only locked up. I used to be a prosecutor myself way back in the prehistoric days. There are guys who get arrested over and over and over again. The cops are first like, you got to do something, so let's set bail and have the guy sit for a month or 2. Typically, substance abuse, mental illness, homeless are all factors there. It seems to me that's not the ideal way to address that specific problem. The guy's going to be out in a couple of months, be back urinating in front of a restaurant again. They're going to call. The cops are going to say, I don't have any other options. And these solutions are outside of the scope of the criminal justice system. And that's why I think, to be fair, I advocate to other people looking at other systems to say, you got to fix this part of this system, take some pressure off the criminal justice system. And I got one last thing to say. In New Haven, where I live, I'm a member of the New Haven Board of Police Commissioners, and we have a very innovative initiative underway, and it's not unique to New Haven, it's happening in various places around the country, where the 911 operators, when they get a call about a situation that seems to involve someone who's homeless, mental illness, have the option of dispatching special workers, not law enforcement officers, to that to address it. I've done ride-alongs with the police and ride-alongs with, it's called Compass, and the police love it. The Compass people are very dedicated, and they're able to deal with a situation to take the burden off the cops. The cops are thrilled because the amount of paperwork that goes into dealing with someone who's homeless when you have no other option but arresting them is crazy. And those are the people that are taking up a lot of beds in the Department of Corrections. So this is, I don't want anyone to assume that I'm criticizing anybody or any entity or any position in particular. It's a system problem that needs to be addressed, and the bail system is, in my opinion, a large driver of these bad outcomes.
If I could just, one thing that I would like to underscore also is the number of questions and the amount of discussion that's really being devoted to data here. And just underscore, number one, we are very lucky to be in the system that we have, because I think with centralized court system and a unified DOC, the data is easier to see, cleaner, easier to interpret. But also just underscore, I think, in the discussions that I've had, this is a lot of the substance of the questions that are coming at us, because this helps us understand what this will look like. So I am grateful to the judicial branch for the data numbers that they've put out. I know the governor's office has put out numbers, and I know that with the Sentencing Commission, individuals on the commission are working to get even more complete, granular, and comprehensive data to answer a lot of these questions, which I think also connects to the community education portion of this, and the desire of all of us to be answering the questions of the community about what this might look like, so that everybody can understand when the representatives and their senators are voting on this, what exactly is being moved forward. So. Other questions?
Hello, my name's DeAndre Grimm D. Burke Brown. As most of us know, before I even get into this, I want to say that I know the prison system through experience. I was incarcerated for over 4 years. As we know, or what's been going around about this state, is that we are the cop-out state. A lot of people take sentencing that they either don't deserve or they don't know what they don't know the law, so they take the sentence that they are offered, whether it's in seg or in front of a judge. So what I want to understand is, how can we make it so our inmates and people are incarcerated are more educated? Because half of these prisons are taking the law books from the prisons, and half of these people don't know the law. And another thing is, half of these people are innocent. Sometimes they get charged with something they didn't even do. So I want to know from all y'all how, in a way, in the future, this could be helped, because there's people that are incarcerated that go through mental health, that are overly medicated to the point where they are taking 20 years for things they didn't do, or for things they don't really know how to work the system. They don't know the law. So they're taking 20 years for something that they should have took 5 years for, or 2. So I want to understand how, in which way we can make the system more fair for the incarcerated youth, incarcerated young adults, incarcerated adults, because I've seen a cycle of revolving doors, because prison isn't held accountable for being rehabilitation and being a place to where when you leave there, you have something to come home to. And some people don't have anything. There's some people that are orphans that come home to nothing. There's some people that have no people at all that come home to nothing. And if we're supposed to be rehabilitating people, shouldn't we be providing resources so we can make them come into humanity, like so they could come back into society as humans? Because it feels like inside there, people aren't treated like humans. And I feel like that's really the big problem, which is why people come out either worse or come out doing the same thing. So I feel like we need to address that part. If any of y'all have any thoughts about that.
Well, if no one else is going to say anything, I'll say something. So, I mean, it's a valid point. Obviously, big picture solution number one is incarceration should be reserved for people who need to be there, right? I mean, and I think part of the problem is we have a lot of people who don't really need to be incarcerated. Maybe they deserve it, but they don't need to be, right? And it's, you know, and it costs about, on average, about 70, 80 grand per person per year to incarcerate people in our state. It's a lot of money, right? But some interesting trends, right? It used to be that in Connecticut, if you broke out everybody who was incarcerated by age cohort, that prisoners under the age of 30 were by far the biggest cohort. Now it's the smallest. The only one that's growing are people who are incarcerated over the age of 60. It's the only part that's growing. There's more of those than there were when we had 20,000 people incarcerated. And I think a lot of that has to do with these very long sentences that were imposed mainly in the 1990s. And it's worth noting, you know, some people in here, I'm sure, have studied what goes on in other nations. There's almost no nations like ours, you know, developed democracies that lock up even murderers for more than 15 years on average. I mean, the sentences that get handed down in this country are way off the charts compared to any other nation in the world that we would like to be compared to, right? I mean, just really hard to believe. When people visit our prison system from other nations, and I take them through frequently, they're shocked at the number of people serving 60, 70, 80-year sentences with no possibility of parole. I mean, this is unheard of in the rest of the world, right? So I'm just put that in perspective. In Connecticut, however, to your point, there have been so many changes that have been made in the way young people are dealt with by the system, especially juveniles, persons under 18. This was a heavy lift, a major change, required a lot of planning for implementation that actually worked, and it did work. And I think part of the reason, part of the proof of that is there's so few young people being arrested these days for any crime. And when I say young, I don't mean juveniles. I mean 20, 21, 22, 23. The number of those people being arrested has been dropping steadily for 15 years. The number 30 and older is about this, that rate is not changing a whole lot. But it's, so to me, the best and the most encouraging trend we're seeing is that fewer and fewer young people are even being arrested. And again, I'm not talking about juveniles, I'm talking about late teens, early 20s. That's where we've seen the big drop. There's so few of them in the DOC, and the DOC population is now challenged. How do we manage older people, elderly, with all the health problems that go along with that, who are not eligible for parole? And that's why you see the parole board and others reconsidering release options for people who've been locked up for decades, who are physically debilitated. And I think that's a trend for the future. But there's more that needs to be done, no question about it. But I think at least in our state, we're heading in the right direction in that regard.
I would agree with you that our state needs to do a better job with regards to providing those that are incarcerated with a fair chance at assisting their attorneys in their defense, meaning law libraries and information that needs to be there to help adjudicate the law. I did 30 years, and pretty much all the books and all the facilities that I went to are outdated. You're either purchasing your own law, Georgetown Law Journal, you're purchasing your prisoner rights handbook from outside sources where I think these need to be readily available for you in the libraries. And I think some of that comes from the fact that once one becomes woke, as they would say, or knowledgeable in that field, a lot of times individuals that feel as though they are oppressed by the Department of Corrections begin to challenge and try to right those wrongs from within. And that's not something that they've been comfortable with. So I think that for some reason they found a way to, cut down on the number of law books that are in there. They don't replenish them when case laws torn out of the book or the books are discarded. So you have very few books in there, and they have ILAP, which is an inmate legal assistance program, which only will help with civil cases. And most of the time we're fighting a criminal battle, and we're not fighting for civil cases. And you find a lot of guys who do fight civil cases, and they even cop out on the civil cases because they have 50, 60 years that they copped out to, and they have very little support on the outside. So every chance they get that they can, go up against the state and say, okay, I can get $3,000 for this, I can get $3,500 for this. This is why we see Civil 1983 is an influx probably in the state of Connecticut because of that. But I think if we had a just system on the inside, meaning a law library, I think you'll find less of that. But because there isn't, because individuals will be fighting for their freedom more so than fighting for a couple of dollars that they're going to spend on commissary. They're going to spend. They're basically giving the money back to the state once they settle. You know what I'm saying? So if we had an adequate system in there, individuals will be able to assist themselves on fighting for their freedom as opposed to trying to think of ways to monetize their stay while they're incarcerated.
If I could just add to that, first of all, I want to thank you for your question, and also thank you for sharing your own experiences. And thank you for the connection that those issues have to the conversation that we're having about bail. So I can say, as a director of the Criminal Defense Clinic, we field a lot of concerns from the community about how things are working in prisons and in criminal justice system more broadly. Two of the major categories that I hear about as a clinician are the ones that you've identified. Is number one, people who and their families who are dealing with the incomprehensibility of the plea offer that's in front of them, or the plea offer that they've taken, or what happened to them after turning it down and going to trial. That's one large category of concerns that we field. And then the other one is the problems with the access to legal research materials and access to the courts within the prisons. And those two are very connected. So I can say, as a criminal defense lawyer who's been practicing for 20 years now, counseling somebody about their plea options while they are incarcerated is a wholly different experience than counseling somebody who is out there in the community and surrounded by their family and their loved ones. And it is very, very difficult given the conditions, the environment, the trauma, and the issues that so many of our clients are facing that need treatment. So I appreciate the connection that this makes to the larger discussion about how we move forward and the concerns that we think about.
So I have a question because I know that you guys have spoken a lot about, recommendations from panels and from commissions. However, when I've seen this law go up at the Capitol a couple times, just simple bail reform laws being proposed and sentencing restructuring, I've noticed that there's lobbyists and bail bondsmen in full force giving out handouts and just providing misinformation when it comes to what can result from, cashless bail systems and how they'll imprison enemies of the state, which, we're Connecticut, so I know we're going into a new administration, but even then we're in Connecticut. So as we continue to push for this reform, which has been proven successful in other states, how did you plan on overcoming that challenge?
Well, I'll say one thing on that topic, because having been in the legislature for a long time, the opposition from the bail bond industry, which is, it's a little bit less so today, but it's a very lucrative business in every state, almost every. Some states don't even allow it, but people can make a lot of money doing this without a lot of risk. And I think that's what drives this. So they hire the best lobbyists at the state capitol, lobbyists for whom I have a lot of respect, but still they're the best, and they're also the most expensive. The good news is that one of the best outcomes of the recent election here in Connecticut, in my opinion, is Connecticut's legislature is going to have one of the foremost experts on this topic as a member of the legislature. She's here today, Representative-elect Renee Lamarck-Muir, who back in the day led the studies to identify for people like me, legislators, what the problems were with the system. And trust me, there's a lot of problems with the oversight of professional bail bondsmen and licensed bail bondsmen in our state and in every state. I mean, it has led to what I think is I'm not saying anyone is corrupt, I'm saying it's a corrupting influence on the system for things to work like this. And I know I mentioned this earlier, but I think it's relevant now. You know what is the scariest thing for me to see at the moment? On the New Haven Board of Police Commissioners, we interview all the police officers who are being promoted to detective, to sergeant, to lieutenant, to captain, and I ask them, how many times have you testified in a trial in your career? We're talking about people who've been on the job for 10, 12, 15 years, and almost all of them say 1 or 2 times. And in those instances, in federal court, not in state court. And if it's in state court, it's in the Part A, not the Part B. And not in motions hearings. And I think part of the reason for this is the ability to get people to plead guilty, especially those being held on bail, is like plead guilty, get out of jail, which is like this weird, contradictory thing, but that's the way it works a lot of times. And again, I'm not accusing anybody doing anything wrong. I'm just saying the system has gotten to that point, and I think this is bad for the system where there's almost no actual litigation taking place in our lower courts.
I think we have time for maybe one more question.
Okay, I just wanted to make a couple of points. Coming from law enforcement, working 18 years as a detective, and then retiring, I'm seeing both sides of the justice system. So I just wanted to make a couple of points. That excessive bail can't afford a person to fight their case if they're incarcerated. And the amount of things that they see while they're incarcerated, especially in Niantic, where you have the general population with pretrial, it becomes a problem. The amount of time that's spent on our overworked public defenders is minimal, so that does not give the person the opportunity to fight. And then reasonable bonds and the use of bracelets would allow that person to earn the money that is needed for proper defense. So not saying that public defenders aren't able to effectively help these clients that, I'm gonna say clients, but when you have a private attorney, you have more time to be able to spend with them, to be able to explain to them your case and be able to gather the evidence that you need, that in your case would be helpful. But if you're incarcerated and you have excessive bail, that doesn't afford you that opportunity. So I just wanted to share those points, and thank you so much for all that you guys are doing up there, because Connecticut could use all of this advice. Thank you.
Thank you. I'll give, if any of the panelists want to respond to that or anything else that has been raised.
Okay, great. Hi, everyone. I'm Chelsea Infinity. I'm here with the ACLU of Connecticut, too. My question is for Attorney Lawlor or anyone else who wants to take a stab at answering. I heard judicial discretion mentioned a couple of times, and my concern is that the Connecticut State Judiciary is made up primarily of folks from prosecutorial and corporate law backgrounds, and we know that empirical studies show that, judges with those background or from those backgrounds or with those backgrounds tend to side more with prosecution, typically be a little bit more against pretrial justice related issues. And also, there is really not, the bench really lacks diversity, and I think the numbers as of like 2022 are 15% of Black judges and maybe 9% of Latinx or Latina judges, and in my opinion, that's really concerning, because if you're not, if you don't have that firsthand understanding of the person in front of you, the defendant's experience, and you also don't have any experience directly working with people from historically marginalized, undervalued communities, I feel like that does limit perspective a lot. And so we've said that, I've heard that things have changed, and I guess my question is, what are we doing to address the implicit bias, specifically of white judges and judges with those from those particular backgrounds? Because as much as things, may have seemed to be changing, I feel like for people who look like myself and for people in the communities that I serve, the racial disparities persist. And I think that also really comes down to who is represented on the bench as well. And I'm wondering how we are measuring how things have changed as well. Thank you.
Well, since you directed that to me, I thought I was out of here at that point. But no, but seriously, I don't want to speak for the judiciary. I can kind of speak from my experience. I think it's important to understand that those are obviously very valid concerns. My experience, having been a prosecutor for the last 30 years, looking at the makeup of the bench from the time I started until now is a much more diverse bench in a lot of different ways, whether that be race, color, creed, sexual orientation, male versus female. I think in particular, Governor Lamont, Governor Malloy have made the leadership of the judicial branch have stressed the importance of diversity on the bench for those exact reasons, that there should be more diversity of opinion, diversity of backgrounds. And as a practitioner in criminal court, I have seen, I think, a marked change in who the makeup of the bench, particularly in criminal court. From your other perspective of implicit bias and how to address that, when I started as a prosecutor in 1995, that wasn't even a term. Right? And from the Division of Criminal Justice's standpoint, implicit bias is something that is constantly trained on, basically on an annual basis with us. I know the judicial branch also has extensive training for judges and for other members of the judicial branch on implicit bias. As a matter of fact, I had a judge of the Superior Court talking to my class at Quinnipiac. No one refers to me as Professor Lawlor. Not to make light of it, but like one of the things the judge was talking about was a question from a student on that exact topic, and we had a rather long discussion on the importance of understanding everyone's implicit bias. No one is unbiased. We all have them, right? To understand what they are, to recognize them, And when making decisions, particularly in criminal court, where the ramifications are so large, that we realize that we have these biases and that we are trying our best to recognize that and to remove them from the decision-making process. So to say that anyone in this is perfect, I would say no, but I think from a systemic point of view, from a bureaucratic point of view of these various agencies, that is certainly something that is recognized and I think being addressed both politically with who's being appointed and training-wise for those who are appointed in all of these different decision-making areas to do our best to try and address those issues with more work to be done, I think.
Can I just add one anecdotal thing? This is my experience. It's not unusual for a former public defender who becomes a judge to be a hard ass, and it's not unusual for a former prosecutor to be a big softy in the court. So it's an interesting phenomenon. I could give you names, but I'd probably get sued. But it just factor. And I don't think a majority of the judges are either former prosecutors in corporate. There's certainly a lot, but there's also a lot of former public defenders, private practice lawyers, and stuff. So.
And I think a lot of the studies that you mention, and I've read a lot of those, most of those do not focus on Connecticut. And I think, that's one of the things that Connecticut can take pride in that maybe isn't found in other court systems where judges are primarily elected. We don't think about that in a lot of other states. You get elected because you're the former DA and you're tough on crime kind of a thing, right? We don't have that here, and I think that that's something we can all be proud of.
Can I take a moment of personal privilege, and this is very serious. A very prominent person in our state has just passed away, former Governor Jody Rell, for whom I had a lot of respect. So maybe a moment of silence. Thanks.
Thank you, Mike, for that. And with that, our time is up, but I know that the discussion continues. Thank you all so much for all of your deep engagement with these issues. I hope to keep hearing from everybody about what your questions and concerns are. I know so many of us are really invested in how this process goes forward, so thank you all very, very much.